Good afternoon, everyone. Welcome to our Wednesday webinar. Birkett Long is offering a series of fortnightly webinars on a range of different subjects for individuals, families and businesses. My name's Laura Mears. I am a solicitor in the dispute resolution team at Birkett Long. This week, we're looking at the impact of COVID-19 on contracts and whether the pandemic is a force majeure event. We'll be taking questions at the end, so please do make use of the Q&A facility. First slide, please. So the agenda for this afternoon's webinar, first of all, we'll be looking at the force majeure clause itself. Then we'll be looking at whether the pandemic is a force majeure event, the effect on contracts where a force majeure clause is invoked, and then what happens if a contract does not actually have a force majeure clause. Next slide, please. So first things first, we need to check whether your contract actually has a force majeure clause in it. Now, that clause does not have to be labelled force majeure. What you are essentially looking for are clauses which anticipate that there may be some sort of supervening event beyond the control of the parties and which relieves one or both parties from performing some or all of their obligations as a result. Now, the key point there is an event which is beyond the control of the parties. So this can be factual, such as a pandemic causing staff to be ill and unable to work, or it could be legal, such as restrictions imposed in reaction to a pandemic, which might prohibit staff from travelling to work. Next slide, please. So the idea of force majeure clauses are to provide certainty to questions being faced by turning them into ordinary construction of contracts. Force majeure clauses will affect any argument about frustration because if a contract contemplates a supervening event, it cannot be said that the supervening event renders performance of the contract radically different from that contemplated at the time of contracting. So this differs from frustration because frustration would bring a contract to an end as it's impossible or illegal to perform. Next slide, please. So force majeure clauses may be very specific in the events that they're listed, but can also be quite general. So for example, they could make reference to performance having to be lawful or could refer to anything preventing performance that is beyond the party's control. Force majeure clauses are construed restrictively and are often subject to limitations. In the Metropolitan Water Board v Dick Kerr and Co, this case from 1918, the clause here purported to cover delays howsoever caused, but the House of Lords held that the clause nonetheless did not cover substantial delays caused by the First World War. Properly constructed, the force majeure clause was only intended to cover minor delays. Now, this was a contract where there was to construct a reservoir. There was a force majeure clause regarding delays that would enable an extension of time to be granted. The First World War then broke out, and in 1916 the Order of Ministry of Munitions came into place, which meant the work had to stop. The contract was therefore treated as having been terminated, as it would have been illegal for the works to continue. Next slide, please. Similarly, in Knockhut v Universal Equipment Co, the Court of Appeal was faced with an employment contract which included a force majeure clause that suspended salary when the employee was absent from work for sickness or incapacity. The court held that this clause was not engaged where the employee had a heart attack leading to permanent disability. So in both of these cases, the court considered that the contract would be frustrated at common law, and the question then is whether the force majeure clause makes a difference. Where there is no question of frustration, the impact force majeure clause may be different. Next slide, please. So many phrases in force majeure clauses are boilerplate, i.e. standard, and have been well litigated. So the language of the act of God is said to mean such a direct and violent and sudden and irresistible act of nature as the defendant could not by any amount of ability foresee that it would happen. He could not by any amount of care and skill resist so as to prevent its effect. So historically, acts of God have been linked to natural disasters such as floods and earthquakes, but could arguably extend to the pandemic. Next slide, please. So the language of force majeure itself can sometimes be used in the clause to define and describe the relevant event triggering the clause. Many force majeure clauses still do not mention diseases, epidemics or pandemics, but this is of course likely to change in future contracts. Next slide, please. So the burden of proof will be on the party seeking to rely on the force majeure clause as to why they need to rely on it. So the non-performance must be due to circumstances beyond the control of the party and for which the party had not assumed responsibility. There must also have been reasonable steps which could have been taken to avoid or mitigate the supervening event or its consequences. You should also note that many clauses do actually exclude foreseeable events. Next page, please. So obviously we've now dealt with the clause itself, but we need to look at whether the pandemic would be a force majeure event. So English law has no general rule of force majeure. Whether the COVID-19 outbreak is a force majeure event will depend on the wording of each contract. Under many definitions of force majeure, the COVID-19 pandemic may well trigger the clause, but the clause will need to be applied to the facts of the case, and that of course is key. Next slide, please. So first thing you need to do is look at the definition of force majeure in the contract. If it's a broad definition, such as a force majeure event means any event beyond a party's reasonable control, the pandemic itself and any consequences beyond a party's control may well be a force majeure event. However, there could be a list of force majeure events. If there is a complete list which purports to identify all of the force majeure events, then whether the pandemic is a force majeure event depends on whether the list expressly includes epidemics or pandemics. Next slide, please. You might also find there is a list of examples, and the clause could say a force majeure event means any event beyond a party's reasonable control, including without limitation, and then it might then provide a list of events. In this example, the pandemic would appear to be a force majeure event if it fits the general description, even if it isn't on the list. So that word there, without limitation, is key. So you also need to check whether the definition excludes foreseeable events. Now, whether something is foreseeable is a question of fact. And next slide, please. So depending on the date and context of the contract, it could be argued that the risk of a pandemic was foreseeable. In recent years, there's obviously been the outbreaks of bird flu and Ebola virus. So on that basis, arguably the pandemic was foreseeable once developments in the Wuhan province began to be reported in the media. However, even after the pandemic was declared, parties could not foresee how it would affect the contract in question. So whilst we have had sort of cases of bird flu and Ebola, the way that the pandemic this time has been handled is really entirely different. We've had lockdown. So on that basis, it's difficult to see or to argue that the pandemic was foreseeable. Next slide, please. So the contract itself and the context in which the contract was made affects its interpretation. So even if there was a force majeure event, its effect on the contract depends on the facts of the case. So, for example, did the event prevent or delay a party from performing an obligation? The force majeure event must have prevented performance or hindered or delayed it, as the contract specifies. So sometimes you'll find in contracts it will use the word prevent, sometimes hinder, sometimes delay. Now all of those words mean different things and have different thresholds, so you have to pay close attention to that. Practically, it may be easier to prove prevention of a supplier's performance than a customer's payment duties. Next slide, please. So we are, of course, all now aware of the risks of coronavirus, but we're still unsure how they will affect our contracts. So if you are concerned that foreseeable risks may affect your performance of your contractual obligations, you could expressly deal with the impact of coronavirus in the force majeure clause, or deal with it in the other terms of the contract, or you could expressly deal with foreseeability in the force majeure clause itself. Next slide, please. So when drafting new contracts, it could be argued that the pandemic is a known risk and is not therefore force majeure. So one way to prevent this happening, or this argument, would be to mention COVID-19 in any list of force majeure triggers. So for example, mention epidemics or pandemics, excluding COVID-19, however you want to deal with that. But then we have the question of smaller outbreaks and whether that would still be a pandemic. Obviously, this is likely to go on for a while. I don't think COVID's going anywhere anytime soon. So another way to deal with this would be to mention COVID-19 in the background section of the contract, as this can then be used to help interpret the contract. So, for example, you could say the current COVID-19 pandemic, while not currently expected to prevent performance, may lead to force majeure as defined in this contract. Or you could say the parties have agreed to deal with foreseeability difficulties caused by COVID-19 under clauses, and then obviously put in there the relevant clauses that apply. Next slide, please. So, as I mentioned, new waves of COVID will of course not be so novel or unexpected, and parties are expected to be better prepared. Even so, if another wave of the virus does interfere with contract performance, it may still trigger a force majeure clause. I think you just need to apply a sort of commercial sense and do whatever reasonable to make sure you can still perform your contracts, because what is reasonable will depend on the circumstances as the parties perform the contract, not necessarily when the contract was first made. So, as I said, what was reasonable at the start of the first wave may not be enough later. Next slide, please. So once you've established there is a force majeure clause and that it's likely to be triggered, they need to have a think about what the effect of triggering that clause is. Now, this again will depend on the wording of the clause itself and the application to the facts of the situation. As I said earlier, force majeure clauses do not automatically excuse both parties from all liability or bring the contract to an end. So depending on the wording, a clause may excuse a party from performing specified duties, those that trigger event prevents. So the procedure for communicating about the event may be provided for in the contract. So the contract may say you need to give notice to the other party, and it may specify how that notice is to be provided. A force majeure clause can trigger termination rights, but not always. As I said, it depends on the wording of the contract. Typically, if the event occurs, common provisions in a force majeure clause may let the parties suspend or defer performance, excuse the parties from performance, or add new termination rights. In most contracts, specified consequences do not follow whenever force majeure is present. Some element of causation is normally also required. So it's not enough simply to show there's a force majeure event. You need to show that that force majeure trigger has prevented your performance of your contractual obligations. Other common provisions may require parties to take reasonable steps to avoid or mitigate the event or its consequences. And again, mitigating your losses in these scenarios is key. Next slide, please. So, as I said earlier on, each clause is different and each contract is different, and there is no consistency at all with force majeure clauses. So you need to look for your answers to any queries that you have in the contract terms regarding your obligations. The force majeure clause may not suspend customers' duties and may only end suppliers' obligations. Some clauses do suspend all obligations except payment duties, whereas some clauses excuse all obligations to the extent that force majeure hinders its performance. This may not help a customer who is still able to pay without an express provision suspending its duty to do so. Next slide, please. However, the law generally does not expect a party to pay something for nothing. Consumer law protects individuals from having to do so. This presentation focuses mainly on commercial contracts, but even in business-to-business contracts, you could still argue that there's an implied term, or that a customer who has already paid for performance that is not received may have a claim in restitution. So, for example, unjust enrichment. The force majeure clause may require you to take steps to avoid a force majeure trigger or to mitigate its effects, but could also be implied. So if the attempt to rely on force majeure fails, then the party in breach is likely to face liability for breach of contract. That party can try and reduce its liability by offering alternative performance or suggesting other steps to reduce the other party's loss. The other party is not obliged to accept suggestions, but rejecting a reasonable proposal could be considered a failure to mitigate its loss. So if a party commenced proceedings for breach of contract and has taken no steps whatsoever to mitigate its loss, or has not accepted what a court would consider a reasonable suggestion, they may find they're not entitled to any damages at all. Next slide, please. So there's often going to be scenarios where the contract does not actually have a force majeure clause, and generally in English law there is no rule of force majeure. So if there is no force majeure clause, no relief will necessarily flow from situations the parties might consider to be force majeure. Fault is not a requirement for breach of contract obligations unless the contract says it is. So if you breach the contract and it's not your fault, it's largely irrelevant. If the failure to perform is a breach, it will normally give the other party a right to claim damages and or terminate the contract. In the absence of express provision, force majeure clause is unlikely to be implied. Force majeure provisions vary widely, and it will often be impossible to identify the precise clause that is obvious or necessary for the contract to work. So if, for example, there isn't a force majeure clause, that's when you might look at possible frustration or potentially something else in the contract that might assist you there. Next slide, please. So if the other party is seeking to invoke or enforce a force majeure clause, they may provide you with notice. But you need to look at whether that notice is justified by the facts and the contract, because if it's not, it may be a breach of that contract and may result that you can repudiate the contract, triggering termination or other rights to the recipient. So you need to investigate the validity of the force majeure notice and assess all of your options. You could perhaps send an initial holding response to the other party confirming you are reviewing the matter, and in the meantime you are treating the contract as continuing on its original terms. This will ensure that you do not do anything which would waive your right to deny the force majeure at a later event, and you can consider your options properly. Next slide, please. So when considering your position, if you have received a notice from the other party, the key point is that the effect of any force majeure clause depends on its wording, its interpretation and applications to the facts. So you need to consider, firstly, whether the contract does actually contain a force majeure clause. As I mentioned just a moment ago, if it doesn't, then the other party can't seek to try and claim that the contract or their obligations are suspended when there is no clause about that. You then need to look, if there is a clause, whether that clause has been triggered. So as I mentioned earlier, you need to consider foreseeability, whether the clause has excluded foreseeable events. You need to look at causation, so you need to prove that the trigger has caused you not to be unable to fulfil your obligations. And as I stressed earlier, those circumstances do have to be beyond the party's control. So it's not enough simply to say there's a COVID has triggered the force majeure clause. You need to say that stopped you fulfilling your obligations and it's beyond your control. If you've done something which means you can't fulfill your obligations, that's an entirely different scenario and force majeure won't help you. You also need to ensure you take steps to mitigate your loss, because that will be key. You need to look also whether the other party has provided adequate proof that they are unable to fulfil their obligations. I think people may find people using all sorts of excuses at the moment as to why COVID's prevented them from fulfilling their obligations, but you can maybe ask for more information as to why and ask for proof of that. You then need to look at whether the other party has followed the proper process of invoking the force majeure clause. So you need to check what the clause says, whether there's any time limits and deadlines, and what that procedure is. So whether you have to give notice in writing, whether you can do it orally, or if you do have to give it in writing, is there a method of service potentially? Sometimes you might find in old contracts, emails not considered written notice, to be really careful that the proper procedure has been followed. Once you've established all of that, you then need to look at what relief the clause itself actually provides and what the other party is asking for. And then last but finally, look at whether anything else in the contract can help you or the other party who is seeking to invoke the clause. So, as I said, you do need to look at the contract itself and what the clause says. And if you do have any concerns about it, it's always best to seek advice, because if you are seeking to rely on the clause and you're unreasonably doing so, you may end up finding yourself in breach of contract, and the repercussions of that can be far-reaching. So tread carefully with this, because it's not straightforward at all. Thank you. So before we take any questions, we'll be sending a recording round to everyone that's signed up to today's webinar tomorrow morning. We'll also include a link to a very short feedback survey. We'd really appreciate it if you could complete that, so we can make sure our future webinars are helpful to you. As I said at the start, this is one of a series of Wednesday webinars. Our next webinar is an employment law update. If you are interested in our future webinars, please visit our website or our Eventbrite page to sign up. And we'll now take questions.
Thank you, Laura. The first question we have is, would a force majeure clause be triggered if a supplier can deliver goods but we no longer need them?
Right, okay. Well, the clause may be triggered, but as I said, you won't just necessarily be excused from your obligations. You'd have to show why you can't fulfil them. It's not enough to simply say it's been triggered. You need to prove it. Just because it may be more expensive for you, or doesn't make commercial sense anymore, that's not generally enough to get out of it. It will depend on you saying the pandemic has prevented you from fulfilling your obligations.
Thank you. The other questions that we've had come in need direct response, so that would be all the questions that we have for today's webinar.
Okay. So thank you for joining us today. We'll review any questions not answered and contact anyone we haven't had time to respond to. Thank you.